In ecological law, nature's intrinsic rights can be fully recognized, resulting in a duty for policymakers and decision makers to act to protect the environment. I'm not arguing here that this does not come with significant challenges, but these challenges will have to be addressed appropriately by 21st century courts. As outlined in our written statement, we do not need more conventions and treaties. Instead, we have to start discussing more proactively from an ecological law perspective, new forms of legal representation, the nature and extent of existing legal obligations, the content and scope of existing legal principles, the concepts of non-regression, inter and intergenerational equity, interspecies equity, and I even dare to say, Your Excellencies, rights of nature. In general, we argue that applying an ecological approach to international legal frameworks for forests will help us better understand and specify the causation of environmental damages and the extent of legal obligations, which should consider the nature's right to exist, to thrive, and evolve.
Legal personality for nature is a tool that states can use to better protect forests at a national level. Recognizing nature as a legal person can also better recognize people's legal responsibilities to protect nature and act as its guardians. These tools can implement our responsibilities under the fundamental legal principles of environmental quality and protection, through better reflecting alternative worldviews of our relationship with nature, such as those held by Indigenous peoples. They can also better uphold Indigenous human rights laws, such as those addressed by our learned friends, the agents from Ecoforestania. This option of legal personhood can be seen to be becoming more commonly used across the world in Aotearoa, New Zealand, India, Ecuador, and Bangladesh. The Colombian Supreme Court used legal personality with regards to the Amazon rainforest. This gives more protection to the forest and acknowledges Indigenous views. The forest is treated as a subject of rights, entitling it to be protected, conserved, maintained, and restored. The state of Colombia is responsible for this. The Colombian Supreme Court based its decision on fundamental responsibilities of states of environmental protection and human rights laws. I note that the Colombian Supreme Court considered itself guided by hard and soft law, international law, not just its own national law, and that this decision was not an isolated one, but rather reflects international trends. This decision flowed on from the earlier Atrato River decision that held the river to have legal rights and that humans had responsibilities to look after it. That case was an important illustration of the court utilising grand narratives about environmental protection. For another example, New Zealand has given legal personality to both rivers and forests in order to promote Indigenous rights of Māori iwi. The Te Urewera Forest was given legal personality in 2014 through negotiations between the Crown and Tūhoe, who are the iwi who claim the forest, which resulted in the title being vested in Te Urewera itself instead of the government. Courts in India and Bangladesh have also declared legal personality to rivers. There are enough countries following this conception to establish that there is an emerging international custom that could exist one day to be binding over countries that have recognized this custom.